Welcome to Cross-Border Tax Talks, where we discuss the latest trends in international taxation, from U.S. tax reform to the OECD's latest developments. I'm Doug McHoney, PwC's U.S. International Tax Services leader. You can follow me on Twitter at XBorderTax. This week, we're still hashtag WFH in Westminster Studios, where I'm virtually joined by PwC International Tax Partner and Value Chain Transformation Specialist, Tom Quinn. Tom has spent his entire career focused on the tax implications of cross-border business models, has dedicated considerable amount of time studying our Subpart F regulations, and is one of a number of my mentors that I'm honored to have on the podcast. Tom, welcome to Cross-Border Tax Talks.
Thank you, Doug. I'm excited to be here. Episode 48, that is unbelievable. Well done.
Thank you, Tom. We just recently had 1 million downloads for all of the cross-border tax talks. So it's an honor to keep this moving. Well, before we dig in and dive into a topic that I'm really excited to talk to you about, I first want to talk about our alma maters. I am a third-generation University of Missouri alum. Tom, you're a graduate of the University of Illinois, and our basketball teams, I looked this up, have been playing in a bragging rights tournament in December every year since 1976. So a year after I was born. So I've been to over 30 of those games over the course of my life. My question for you, Tom, are we going to be able to watch Missouri and Illinois play in December? Are we going to be behind all of this COVID-19 insanity, or at least are we going to be able to get together and watch Mizzou and the Illini face off in what might be a pretty poor basketball game?
I sure hope so, Doug. And if we can't, we'll still get together here in my bunker and watch some old game.
And you guys are way ahead in the series. I'm not going to share those particular statistics. People can look it up if they'd like. So while we are all missing sports a lot, while we're working, maybe we can try to provide some entertainment to our listeners and discuss the recent Whirlpool tax court decision. This is a decision that I think many of us have been waiting for years. Tom, you and I have been debating for as long as I've been a partner, and I think before then, over the application of the manufacturing branch and the sales branch rules, what are commonly referred to as the 954 D2 rules, and how they apply to certain fact patterns and how it works when you have sales activities or no sales activities. And I do want to acknowledge that based on the debates that we've had, I would like to say that apparently you were right, at least on some of these technical arguments that the tax court judge put forth. But maybe before we dive in, can you kind of just give us an overview of the facts of the case and what was at issue here?
I can. Thanks, Doug. Yeah, that would be, I think, a helpful start here. And what happened in the case, Doug, in terms of the background, was something which we see very commonly in the operational world, that companies are trying to go out and develop low-cost manufacturing solutions. Mexico has been a low-cost provider for the U.S. market and for foreign markets for many years from a manufacturing standpoint. And Mexico offered historically an incentive to get companies to come into Mexico to manufacture called the maquila regime. And it started out very much as sort of a customs incentive, providing a duty-deferred type environment for companies to manufacture in, which made it easy for them to come in, move products and components, raw materials and components into a manufacturing site, convert those, and then largely export them outside of Mexico to the US and other markets. So this was a very commonly used manufacturing tool that was available to our clients, and many of them took advantage of it. One of the other things that accompanied this, Doug, this maquila regime, was a special transfer pricing regime as well, and a special direct tax regime as well. So in addition to the indirect tax benefits that were available, it also provided companies the ability to compensate on a related party basis the maquila at a very low transfer price, that the conversion cost plus a small markup was all that was required from a safe harbor standpoint for Mexican tax purposes. Similarly, for direct tax purposes in Mexico, the principle in the maquila arrangement, who the company that engaged this toll manufacturing plant, to the extent that the principal's activities inside Mexico were viewed to be related to that manufacturing activity, there was a PE exemption available as well. So all around win opportunity for companies, and has been around for quite some time. What Whirlpool did in terms of structuring its arrangement is critical to the case. The Mexican manufacturing operation was established as a toll manufacturer, and that was done underneath a Luxembourg principle. So they had an established Luxembourg company, that then entered into a contract manufacturing relationship with a disregarded Mexican company, which was essentially a service provider. In this case, the Luxembourg company owned all of the property, plant, and equipment in Mexico, hence the need for the permanent establishment exemption, which otherwise from owning that property, plant, and equipment, the Luxembourg company might have been viewed as having a taxable presence in Mexico as a result of its own activities. And then what Luxembourg did was it went out and it arranged for sales to be made of its product to the US and other related parties in the structure. What I think is interesting in the case, there's several pages of recitation of the facts in the case. The judge in this instance was not shy in terms of characterizing some of the relationships, but he was indicating that with respect to the Luxembourg company, he made it clear that this was a part-time employee that was sitting in Luxembourg. Otherwise, it was kind of an empty box, adding no appreciable value, in his words, in the case. But rather, it took a look at the activities as well, which were in the Mexican maquila, noted that those were all sort of contractual relationships as well, because it was staffed with seconded employees. And he seemed to be somewhat troubled overall just by the nature of some of the mechanics that were in place around the arrangement. And I think sort of unfairly characterizing the arrangement as artificial, although it's something that we see often very commonly. But what became at issue in the case was the fact that the income which was being earned by the Luxembourg entity, Whirlpool had, the taxpayer in this case, was claiming that the income was all exempt as not falling within subpart F. The IRS took an alternative position. It claimed that despite the fact that the activities might be manufacturing related, that as a result of income being allocated away from the manufacturing activities and to the head office, in this case, Luxembourg, that the rules of 954D2, which relate to the so-called branch rules, were invoked, and as a result that the relating income that was allocated to the head office away from that manufacturing branch activity was subject to subpart F. And that was in fact what the court found. It sided with the IRS and held that whether or not manufacturing activities were being carried on within that corporate structure, the Luxembourg entity with the disregarded manufacturing activities beneath it in Mexico, that because of the fact that income had been allocated to the head office, that income was then within the scope of 954D2 and subject to tax.
So I think one of the important things for our listeners to understand is, we have to layer on obviously the non-US tax implications associated with the structure of this type. And so, Tom, I think you did a great job outlining those facts. An important thing to note is that Luxembourg has generally a territorial system. So it generally does not tax income attributable to a permanent establishment outside of Luxembourg, such that Whirlpool took the position with the Luxembourg tax authorities that because it owned the property, plant, and equipment, the raw material, the finished inventory, which is just the nature of the tolling agreement that the Mexican authorities have agreed to. Effectively, they only tax that the small return associated with the Mexican legal entity, and they say all of those other activities that are taking place at the Luxembourg legal entity do not create a PE in Mexico. Well, the important thing that the judge focused on was that Luxembourg did not tax that income. So what ended up happening is that there was a small amount of income that was subject to tax in Mexico under the maquila regime, and then all of those other activities, the owning of the raw, the owning of the finished goods, the property, plant, and equipment, none of that was subject to tax in Luxembourg because of the nature of their system. And accordingly, there was a big chunk of income that was not subject to tax. And the judge was very focused on the policy of Subpart F, which we'll get into, and the statutory policy as articulated when Subpart F came into the code in 1962, I believe. And so that was, I think, a very important element, at least in the judge's view, with respect to the fact that there was a big chunk of income that was not subject to tax. The other thing that would mention, which I do think is an important fact, is that the one thing that it seemed to be occurring in Luxembourg was that title was transferring. So because of the nature of the tolling arrangement, the Luxembourg legal entity had title to the product, and then it transferred that title to the U.S. or the other territories where it's sold. But there wasn't anything else actually taking place in Luxembourg other than title transfer at that legal entity. There was, however, I'll mention, and we'll get into this in a few minutes, there was a transfer pricing study that apparently said that all responsibility for the distribution, marketing, and sales of products fell to Luxembourg, and that's a direct quote from the case. But even though that was in the transfer pricing documentation, there wasn't anything that I could see in the record that actually supported any of those activities actually taking place in Luxembourg other than title transfer. So with that as a factual background, Tom, maybe we can start where the judge started, and feel free to add any color to what I had just mentioned as well. But let's start with the statutory framework under our just general Subpart F provisions, and we have kind of normal sub F foreign-based company sales, which is D1, and then the D2, which is the branch rules that you already mentioned.
Sure. So, right, Doug, as you're mentioning, so what Section 954 D1 says, or what it's trying to impart, is a policy to say that it's looking for where you have engaged in a manufacturing activity, for example, which might be within or outside of Subpart F. And in taking a look at the underlying statutory rules, I think what's important to focus on is what the underlying rationale was back in 1962 when the Subpart F rules were put together, when 954 was developed. And at that time, what was a concern of the U.S. Congress was to the extent that there was passive or mobile income existing, which they felt was easy for a taxpayer to move to a low tax jurisdiction. So you might have a situation where activities which a corporation would carry out from a manufacturing standpoint in a high tax location, and which otherwise might be eligible for a manufacturing exception or a same country exception from Subpart F, you could still separate some of the income associated with that manufacturing and move it to a branch location, still within the same legal entity, but separated in a reporting standpoint as being part of an exempt branch activity. And so the statute was very concerned about that separation, and it was at the heart of what the Subpart F rules were put in place for, was to manage this so-called portable income or transportable income, which might easily be moved to a low tax or no tax jurisdiction. So when we look at the statutory construction and the words around 954 D1 and D2, they're very much focused on trying to identify those situations where you have separated or have a separation of that manufacturing income from other income that might exist within the structure.
Yeah, and then the D2 rules, as you had mentioned, those branch rules were, and again, intended to prevent a company from doing what was through a branch that they couldn't do through two separate corporations. And that if those rules apply, they have the operation of treating that branch as a second corporation, and then you have to go through and do the testing for foreign-based company sales as if those were two separate corporations. Interestingly, and to remind particularly some of our newer practitioners, that rule was well before the check the box rules. And so things have changed a lot since we've gotten the check the box rules, which has made it, I think, much more common and frankly significantly easier to operate in branch form. And so I think it has then caused, just a lot of taxpayers to have to deal with these structures and the regulations. So Tom, maybe let's kind of dive into the case and some of the rationale, because the judge was very, very focused on the statute here, and there is a lot of, I think, mind numbing. I couldn't call it that because I actually enjoyed this stuff, but what some might argue is mind numbing regulations that are super complicated. We have been debating within PwC, and I've been on a number of panels. I mean, just how to debate the application of these regulations. But the judge spent what, in my view, an inordinate amount of time on the statute, less amount of time on the regulations, to really what appeared to be more a policy or almost intent-based type of decision. But maybe talk a little bit about the court's rationale and how the judge kind of proceeded down its path.
Sure. I think you're absolutely right, Doug, in your characterization that this is very much a policy-based rather than you're going in and taking a scalpel to the regulations. He certainly didn't do that. I think if you take a look at, going back to the policy argument that the judge was following, when you look at the words that are in the regulations, they talk very much about trying to focus on this separation that's taking place between activities and income as being something that you need some tools in place to create. And I'd ask the practitioners who are listening in here to focus in on some of the words that are used in the statute, like activities and branch. And within the code, what it's looking for is a separation where a branch or similar establishment carries out selling activities outside of the place of manufacturing in this case. And the judge was not constrained at all by trying to examine those words around what activities are taking place or whether there was a branch or similar establishment. In fact, when it came to identifying what the activity was that the income related to, he was comfortable, as you noted in your introduction around the facts, of looking at title transfer as being a sufficient activity. And that really has been at the heart of what a lot of these structures have been put in place, and very much a shorthand technique or shorthand discussion. This position around having an empty head office, which is still entitled to or reports some of the income in the structure, there was a comfort that many practitioners took from the fact that this language around activities seemed to be a very physical type of a connotation, that something like the passing of title or the booking of income was of a passive nature and not active in the sense of the words that exist within the statute. So it's kind of interesting that he didn't probe further into that particular element. He seemed very comfortable with the fact that the mere passage of title was appropriate to meet this definition of activity, and that the income that was in the head office or attributable to the head office would be cited there just as a result of that passage of title that was taking place.
Yeah, one of the things that I think is interesting, Tom, is that the regulations still clearly, as well as D2, still have that activities comment or still have that activities language. And what what I had always felt, at least prior to this decision, is that kind of going back to the statutory policy, right, was that they were concerned that taxpayers were going to be separating the sales activities from the manufacturing activities. And a manufacturing activity absolutely involves kind of converting something, right, that as the manufacturing process, and there's regulations on that. But every manufacturer, once it's done manufacturing, has to then transfer its product, presumably to a distributor or somewhere. And so, my view before this decision, and this is what we had debated, was, well, just the mere transfer of title or transferring that product from a manufacturer then to a distributor could not in and of itself be a sales activity. Those sales activities are what the distributors do. It's what salespeople do. And in the Whirlpool case, those two activities, the distribution activities were all taking place in the US, and that was acknowledged. And, other than that transfer pricing language, or that language that was mentioned in the transfer pricing report, there really wasn't anything else taking place. And so, one fundamental question, and I'd love your reaction, does the interpretation, the language still exist in the statute and the regulations? And so I'm struggling as an advisor on how I square that language that is still in the regulations and the statute with ultimately what the decision was made by the tax court judge.
Right. So, yeah, absolutely, Doug. And when we talk about intercompany activity, you're right. Calling something a sale is somewhat strained. What we typically look at that as is perhaps a delivery has taken place, but there's not a selling activity necessarily. There's no promotion that's taking place. You're just passing it on to the next part of the value chain in the corporation without any sort of marketing or sales activity in a commercial sense. And that really is where I think the judge took issue with this, is if we really looked at trying to finite, I think what his concern was, is if we tried to finite something like sales and limit that to a third party situation, that it would still give companies the opportunity to confound the intent of the statute, which was focused on this separation of income. If the branch rules were only triggered once you had something which truly was a sale and involved an activity, that might again sort of limit the application of this. And you're absolutely right. I mean, the bridge that needs to be made here, the gap that exists, is the statute doesn't say that. The statute does talk in terms of activities. And when you move to the regs, it talks about it in terms of sales activities. And what I think the judge was very much focused on, it's almost a situation where the intent has overridden the actual words in the statute. And I don't want to profess that one or the other is right. I just want to observe that difference, that if you read through the case and you reflect upon the rationale here, that it's almost as if going back to the congressional intent and the language in the Blue Book at the time, what the judge has done is determine that that is the principle that should apply, which then the consequence of that is when you take a look at what that means in a future sense in terms of the application of this holding, is it going to be very broad, that this could touch any situation where income of any type or of any description has been moved away from manufacturing activity. That it would seem that what would be a consequence of this is we're not going to work within rules or words like sales or words like activities, but rather it's a much broader range of income, which could become subject to the outcome that Whirlpool experienced in this case.
Yeah, so one of the questions, Tom, that I've been reflecting on is, does this fundamentally change the framework both of the statute and the regulations? And I would posit that a tax court cannot, first of all, change. Obviously, it can interpret a statute and can interpret regulations. And what I actually find almost ironic in this case is that the tax court did not spend a lot of time parsing these regulations that we have spent so many hours contemplating, kind of, again, sort of had the more results-oriented decision. but then at the end of the case did have the opportunity, because one of the petitioners, one of Whirlpool's arguments was that these regulations were invalid. And so the judge kind of dismissed, frankly, some of the detailed mechanics of the regulations. There was even a Hemingway reference, which you got to love tax court decisions with Hemingway references. But so effectively did not really respect the regulations, but then also held that they were valid at the end of the decision. And so I'm really struggling with how we square what is still in the regulations with the tax court decision. And the way I am trying to think about it and welcome your views is that, well, we need to apply the regulations to these set of facts, right? Because this tax court decision will apply to these set of facts. But as you well know, there are just a almost infinite number of variations of different business models, even outside the maquiladora context, where we need to try to apply these rules. And so
Right.
how do we try to square this new interpretation of these regulations, if you even want to call it that, with what the regulations still say?
Right. And that's our job as practitioners, I think, is first and foremost, we still have to look to the law. We need to look to the code and the regs that have been created around this, interpreting the language within it in what's been provided to us by Congress and by Treasury. So that's still an important part of our job. And in that sense, what the judge did in this case, he did sort of help us interpret at least one area, which is around if you wanted to try to take a very narrow definition of the term activities, which does exist in the regulations, is he saying don't do that, because we think, or he thinks, just anything can be an activity. It can be a non-physical type of act as well. It can be something like just booking income or passing title through an entity. In that sense, I think the regulations haven't been at all harmed, or there wasn't any sort of disregard to those regulations. But the second thing that we need to do as practitioners, which I think we always need to do, is not draw too much comfort from just the words that exist in a statute or the regulations. Yes, that's important, and we want to be hyper technical in our analysis, but we still got to take a step back and look at what was intended and determine, if we fail on a technical argument, will we still have a policy argument left behind? And that's good tax planning, I think, is to, in any case, not just the subpart F area, but to make sure that as we're making very deliberate and precise arguments that take a literal reading of the rules themselves and as they've been written, do we still feel comfortable that we can make that policy argument if we have to? And I think that's where, if you take a look at the Whirlpool facts, there might have been some things done which could have helped out the taxpayer in the long run, that if you really did, it's pretty clear that there was a lot of activity taking place in Mexico. The taxpayer in this case owned assets, had employees as a result of the check the box rules. If that income could have been, and if the facts would have supported that all the business processes, including things like title passage, were taking place in Mexico, I think the taxpayer would have put himself in a much better position from a policy standpoint of being able to show that he had not separated income associated with those activities and put them in any other place but the place of manufacturing.
Some sage wisdom, Tom, on the policy front. And I think that it's really sort of, it's our nature as tax lawyers and tax accountants, right, to really get into those technical weeds. And I love those word puzzles, but it's an important reminder to step back and kind of think about what had happened, the policy, and making sure that beyond being on all fours of the statutory and regulatory language, but stepping back and thinking the policy, I think, is an important lesson from this case for sure. One of the other arguments, Tom, that the tax court really didn't spend much time on, which was very disappointing to me, was once the court concluded that there was, sales activities or sales or purchasing activities, and we ended up with a manufacturing branch and we're testing to figure out what would be allocated back to the remainder. The way those rules operate is that once you have a manufacturing branch, that you have to draw a box around them, is what we call, or in other words, treat it as a separate corporation for U.S. federal income tax purposes. And there was some discussion about the tax rate disparity test because without getting into a lot of detail, generally the way the rules work is that they wanted to prevent companies from being able to separate, for example, the manufacturing activities, which may take place in a high tax jurisdiction, with sales activities, which would be in a low tax jurisdiction, to create the subpart F. In other words, separating kind of the high tax and the low tax. And so the court, I think, as applying the rate disparity test, said, well, listen, Mexico is subject to tax on a sliver of those profits in Mexico at 17%, and that the residual income or the income back at the remainder wasn't subject to tax in Luxembourg, so that was 0%. And so it kind of thus implied that, at least for purpose of the tax rate disparity test, you actually look to see under local law principles what income was subject to tax in Mexico, which makes sense to me. But then once you fall within the branch rules and you have to treat it as a separate corporation, my view, and I think still view, is that, well, you would then need to look to arm's length principles to determine how you would allocate income between the manufacturing branch and the remainder. And in this particular fact pattern, pretty much everything in the court acknowledged was taking place in Mexico. Now, some was at the Mexican disregarded entity. A lot of it was most of it was at the Mexican branch of Luxembourg through the property, plant, and equipment, the RAWs, and those activities. And again, the only really thing that seemed to exist in Luxembourg was the title transfer. So if you would then draw a box around those two different entities, I'm no transfer pricing person, Tom, as you well know, but what I've learned over the years is that risk of loss does not get much, if any, of a return under transfer pricing principles, which would then tell us that all of that income really should have been allocated to the Mexican CFC or the deemed Mexican CFC. And if that were the case, none of this would be subpart F income. So do you think that omission was intentional, Tom, or what is your reaction to that? Because it's something that I've still really been struggling with, and maybe it's just something that we're going to have to wait for another day and another tax court decision to try to get an answer to that.
Well, that part's true, because you won't find the answer to that, I don't think, in the Whirlpool case itself. But yeah, the transfer pricing aspects of this, I think, are really important. What's said and what's not said. And when you think about, again, what a taxpayer might do to help themselves out in this case, if you know that the concern from a policy standpoint is that separation of income, is take every opportunity you have from a transfer pricing standpoint to document what the return is that is associated with the manufacturing operations themselves. What's important with respect to the maquila arrangement here is that the maquila has a special regime in Mexico, as we mentioned before, that it's subject to a different set of transfer pricing rules that are not necessarily arm's length rules. They're prescribed and formulary, and they will always result in an outcome which is going to be lower for compensation of the manufacturing location than what you might find in an arm's length inquiry. And the court in this case didn't spend a lot of time trying to measure or reaffirm what the income allocations were. But I think it was an important point, just as you said, to make sure that what was happening was the taxpayer in all of his documentation was pointing to the fact that Mexico was entitled to this income, and that the manufacturing operations generated this income. It's a fact that no one should be ashamed of, that there is a distinction between the way Mexico requires the related party compensation to be measured. But I don't think the taxpayer provided himself many opportunities to present that argument because of things like the title flow that surrounded it as well. So yeah, one other observation too with respect to transfer pricing, which is incredibly important, is, as a taxpayer, you're always in control of your facts too, until you write them down and they've been given some time to age. Because what the court also pointed out in this case was the taxpayer had documented perhaps some different facts in his transfer pricing documentation, different views of the same facts in different reports. And it's unfortunate, I think, but what had been presented to the government in Luxembourg was to indicate that where they said, in fact, that we do have a permanent establishment and in Mexico, while at the same time they were yet no income was allocable to that. The court that left an impression upon the court, the fact that they was able to find a transfer pricing report for Mexico, which seemed to indicate a different outcome than what was provided as detail to the Luxembourg government in their ruling. All those things are explainable, but when they've been, again, written down by the taxpayer who had control of those facts and then left to age for some time, that becomes a very difficult thing to argue against with the court going forward. It leaves an impression and it leaves a record that can be very difficult to argue against. So, a couple really important transfer pricing takeaways from the case as well.
So, Tom, do you think that the decision would have been any different post-U.S. tax reform? Because, back in 1962, when Subpart F was originally enacted, that was really the movement into what we had referred to as a deferral regime, right? Income was not subject to U.S. tax until it was ultimately in the cash was brought back to the U.S. in the form of dividend or similar distribution. Subpart F was enacted to try to prevent moving portable income, if you will, around into low tax jurisdictions. And the judge was obviously very focused on that, as we had discussed earlier in the podcast. Well, now we have this new system of GILTI, of our global intangible low taxed income. We have spent a lot of time here on Cross-Border Tax Talks talking about GILTI, which now all of that income, even if it was not Subpart F, would have been subject to tax at GILTI. Now, obviously, that income would have been potentially subject to the 250 deduction, so subject to tax at 10.5% as opposed to subject to tax at 21%. But do you think that this new GILTI regime sort of changes the calculus, or at least from a policy perspective, with respect to how the U.S. tax system works currently?
That's a great question, and it really does reflect something that people have been struggling with in terms of the tax system since tax reform, TCJA, a couple of years ago, which is, Subpart F system still exists out there, and it's still very important to many companies in terms of their overall tax liability. But they are still separate systems, and they're still not integrated in that sense. That when you take a look at what Whirlpool was trying to achieve here, which is a structure that many other taxpayers have put in place as well, was it was directed at trying to preserve the deferral of income offshore. And GILTI says, yep, there's no such thing essentially as deferral of income offshore unless it's been subject to a rate of tax, which will allow us to sort of fully offset that with the tax that's been paid offshore as well. But Subpart F, I think, it's still there. It's still something that is important in terms of its overall influence on a company's structural tax rate, effective tax rate, and one which, when we think about it, we still need to think about it independently. I don't think there's an integration of that. That yes, when there was Subpart F was the first attempt to try to look at offshore income, and it was concerned with the portability of income. GILTI is associated with it picks up any kind of income, doesn't have to just be passive. It just takes a look at, has it been subjected to a sufficient rate of taxation outside the U.S., and if not, there's incremental U.S. tax to pay. But the court in this case, they weren't really struggling with whether or not the income had been subject to tax. That particular concept now in the terms of things like the anti-tax avoidance directive, the so-called ATAD rules, that are focused on hybrid type situations where you're creating untaxed income or non-taxed income is at the heart of what those rules are at. This wasn't really focusing on non-taxed income. Subpart F doesn't focus on non-tax income. Subpart F is focused on sort of the type of income that you have. Subpart F does provide a high tax exception that says that there's a certain level of taxation, 90% of the US rate, in which we don't care if you shifted away that passive income or mobile income. But to answer your question, it's a great question, Doug. I mean, does somebody need to sit back and think about the integration of those two systems from a policy standpoint? If they would have put GILTI in, maybe they wouldn't have had to put Subpart F in back in 1962.
Totally agree, Tom. Maybe here, just at the end to wrap, would love to hear your views on what advice would you have for taxpayers. One of the things I think that we are going to see as a result of COVID-19, and frankly, even before COVID-19, as a result of the trade wars that we've seen and we've dedicated some time to, is that supply chains are going to be changing. And whether it is related to medical equipment or just, the trade war that is still ongoing, supply chains are going to be changing. What advice would you give post Whirlpool decision for taxpayers and advisors as we're starting to rethink, how we structure those and obviously in a tax efficient manner to try to maximize overall cash returns associated with those changes?
I'm not sure that has changed a lot. I think that some of the things that I learned a long time ago are still applicable today, maybe even more so in light of that. And at the end of the day, when you take a look at tax planning and what we try to do, it's important, incredibly important, that they complement and enhance the operations of the business and don't sort of conflict with them. And I mean that two different ways. First of all, we've done a lot of planning around principal company structures, manufacturing structures, things like you're seeing in the Whirlpool facts. And one point of judgment that will always be made about a tax structure is, did that interfere with or preclude any operational effectiveness? And in the case of the maquila situation, I think we passed that test. The tax professionals passed that test. Is that what a maquila was, as we talked about in the introduction, it was an operating incentive. It was put in place to help companies to encourage manufacturing in Mexico and to make sure they could do so in a way which avoided a lot of administrative complexities. So that box gets checked. What we also want to say, I think, is that with respect to our tax planning, is that we have helped underpin the way the business operates, that our explanation is always consistent with this is how the business operates, that we're not doing something artificial, that there's an explanation for it as well that can be provided. And to put that in the Whirlpool context, what I'm saying there is that if you were to explain to someone who happened to be in the marketing department or happened to be in the quality assurance department what was going on in the planning and trying to explain why income existed in any place other than Mexico, is it something that's easily explainable, that's understandable? It needs to be something that we can always be able to fall back and say we can explain it to others in the business. They're helping to operate the business from the standpoint that they can say, yeah, that makes sense. That's the way we operate in this case. The income, it should be in Mexico. And I think that would be consistent with the outcome we'd want to see to build a defendable case under the Whirlpool decision, is to be able to say that, to go back to the court and say, all my income belongs in Mexico. It may not all belong in the Mexican maquila entity because of the way that Mexican tax rules work, but any of that incremental income is associated with those manufacturing operations. And that's a story that you can tell to the quality assurance guy or to the marketing guy as well. So yeah, two rules I think that you can check off here. One would be that let's make sure we sort of do no harm to the business, that operations can operate effectively and unimpeded. And secondly, that it's explainable in the sense of that story is how the business operates.
Well said, Tom. And we're going to leave it at that. So thanks for tuning in to this week's episode of Cross Border Tax Talks. Thank you, Tom Quinn, PwC International Tax Partner, for joining me on Cross Border Tax Talks. I'm Doug McHoney, PwC's U.S. International Tax Services Leader. Stay tuned in 2 weeks for another exciting edition of Cross Border Tax Talks.